I'd now like to invite the panel to come up to the stage. I'm afraid that the surprise has been given away. But as Alex said earlier, I'm really delighted that the way we work at CERRE is by having steering committees made up of a different variety of both corporate and regulated interests, and hopefully you will see that in the discussion today, where I'm really keen to kind of draw out some of the similarities and differences between the different panelists. We've got Buscke, from the Senior Legal Officer at BEUC, the European Consumer Organization, Leonard Wetzel, Manager of EU Public Policy at Snap, Eugene McQuaid, Senior Public Policy and Government Relations Manager at TikTok, Dries Cuijpers, Senior Enforcement Official at ACM, the Dutch Competition Authority, Tim Stok, Director of Public Affairs at TikTok, Martin Prieditis, Deputy Head of Unit at DG Just in the Commission. Oh, sorry, Tencent. Apologies. Yep. And online, joining us, if the tech gods have allowed it, is Amelia Fletcher, one of the authors of the report. So I'd like to start by asking, and we obviously have a big panel, so I'm going to have to ask you to keep reactions very short, 2 or 3 minutes, if you can. But I think maybe just a good opening question for each of you would be, kind of, what did you like? There's obviously a lot in this report, including thinking about ways to align the need to better protect consumers online with this competitive agenda, which means we need to be proportionate and targeted. And so it'd be great to know, kind of, do you agree with that? And what are things that you like about the report? And is there anything that you don't like or disagree with? So Ersk, maybe you'd like to go first.
Thanks so much. Good morning. I think it's still appropriate. Good morning. So yeah, thanks a lot to the two authors for their interesting report on how the protection of consumers could be improved. There's probably one topic, one recommendation that I think we can support, and that is the one on subscriptions. Consumers nowadays, and probably many of you, use a lot of subscriptions. And as you certainly also know, it's quite easy to subscribe to a service. But usually, it's quite challenging to cancel a subscription. The Digital Fairness Fitness Check report has found that 96% of consumers find it difficult to cancel subscriptions. Or a couple of years ago, our Swedish member tested 20 service providers and found that they all use dark patterns to make cancellation difficult. Germany and France have moved forward and have adopted national rules to help consumers in this regard. But we think we need a European solution for this. So here we really support the idea of proposing an easy cancellation function in consumer law. Regarding the recommendation, I cannot support that much. Well, first of all, it's the problem, I think, that the report doesn't cover all the areas that have been identified as problematic for consumers in the Digital Fairness Fitness Check report. The report really gives an excellent overview of the challenges that consumers face nowadays online. And just 3 examples maybe of really important areas that are unfortunately fully absent from the report. One is dark patterns. You all know dark patterns because they're everywhere. 97% of the most popular websites and apps in the EU use dark patterns to influence your decisions. Another area, issues related to video games. We speak a lot about video games here in Brussels, and therefore I'm really surprised to see that the report does not cover consumer issues in video games. Third topic, influencer marketing. Again, I think is high on the political agenda already, and still the report doesn't cover this. And maybe a horizontal issue that is also lacking, I think, in the report is the burden of proof. The burden of proof is a very important topic for consumers, because the DFA has the potential to increase protection for consumers, but it will make no difference no difference if consumers won't be able to enforce their rights. And the burden of proof is one of their main obstacles. Again, it's worth looking into the Digital Fairness Fitness Check report, which acknowledged that consumers face, I quote, excessive difficulties when meeting the burden of proof in technically complex cases. And the report continues saying that this can make the right of compensation practically ineffective. So if we don't do something on the burden of proof, the DFA will remain meaningless for consumers. Thank you.
Thank you, Ask. Well, now I hand over to Leonard, and I'm wondering, in addition to kind of things that you like or do not like, whether you agree that there is more that the DFA should include than what our report recommended.
Yeah, first of all, good morning. It doesn't feel like morning for me. I had an early train, so good afternoon. So just maybe very quickly representing Snap. Snap is, for that you don't know, is the company behind the visual communications platform Snapchat. Snapchat was designed as an alternative to traditional social media platforms until today. The primary use case is the communication in a sort of more creative and visual way, I think, than on traditional messaging services, but it's really just helping users engage with their close friends rather than just scrolling passively through feeds of content. On the well, could there be more in the report? I guess, but I think then it would have been 600 pages and not 60, and I don't know whether this would be digestible for the sort of busy policy bubble in Brussels. So just quickly maybe on what we like and maybe what could even require a bit more attention. I think what is positive for sure is that the report acknowledges the already existing complexity in the area of minors protection when we look at the regulatory framework. I think we all know that there is currently a very dynamic debate around minors protections in Brussels and across Europe. It was mentioned earlier already. And I think it's important that there is renewed attention on minors protection, but I think it's also tempting to overlook the sort of the work that has been done over the past few years in really establishing a dense and robust framework. I mean, for services like Snapchat, we are a very large online platform under the DSA, so we're, we undergo annual risk assessment and comprehensive mitigation measures, independent audits. There is the specific framework for minors protections under Article 28, which lays out requirements in various areas, including user interface design, default settings, user support tools, and so on. So I think that the policy challenge here really is to assess where genuine gaps are in the existing framework, and to ensure that the DFA is really coherent with the existing framework, rather than, and I think this is what's been said here already, rather than running into a situation where there is a strong risk of duplicating rules, which I think ultimately wouldn't lead to a situation where there is a high level of protections across services in the digital ecosystem for minors.
Thanks, Leonard. Before we move on to Eugene, I just want to make the point that for those who are following us on Zoom, feel free to add a question into the Q&A function, and through the magic of technology, it will find its way to my phone, and I will pose it to the panel if we have enough time. So do feel free to think about your questions if you are online, and of course, the same is true in the room. Over to you, Eugene. Really keen to hear what you have to say about what you like and don't like.
Super. Thanks very much, Zach. And yeah, Eugene McQuaid from TikTok. I probably don't need to explain what TikTok is. But in terms of the report, I mean, I say it's very comprehensive. There's a lot of issues to address. CERRE previously did a very comprehensive paper on online choice architecture, which I think really addresses the dark patterns concept. In terms of what we, I guess, stuck out to me from the report is the real emphasis on the importance of the DFA, whatever that form that may take, omnibus or other, that it should focus and strive at a level playing field. And it is this level playing field that will ensure that the DFA will match the European Commission's commitment to simplification, competitiveness, at the same time as addressing the identified gaps. I think that sort of holistic recommendation underpins a few of the other, I guess, findings of the report. A few of which I'd just like to mention. So the report is clear that there is a detriment, particularly to minors, by the fact that certain services, and only certain services, are covered by minor-specific rules. Leonard mentioned VLOPs, for instance, under the DSA. And this is a gap. I think John mentioned the importance of a European-wide approach, and this is maybe a gap that could be addressed at European level. Secondly, and I think Christoph mentioned and emphasized this earlier, the report goes into the concerns around certain design features regarding personalization, but at the same time really emphasizes the benefits of that, and therefore the need to take an approach which is risk-based, principles-based, and proportionate. And I think there is a possibility here that we take a prescriptive approach that's not future-based. And I think many of the, let's say, the features or personalization that we're discussing here, they were not being discussed in the context of UCPD at the time, even at the time of the Modernization Directive. So to allow us to have flexibility, the rules need to adopt this kind of approach. And then finally, when it comes to coherence and simplification, for instance, I think the report makes a really important recommendation that when you're looking at applying sector-specific rules more broadly, and again, the DSA and some of the points there were mentioned, the compliance of those actors covered by the sector-specific regulation should be considered compliant under the DFA as it comes. So I think that's a really important recommendation. I've probably taken enough time very quickly just on sort of what we could have seen more. Again, Christoph mentioned that in certain circumstances, a more prescriptive approach may be required. Subscriptions was an example, personalization another. And to try and find a balance between principles-based and prescriptive, one of these solutions could be secondary legislation. I think Kai, trying to find him in the room, made a very good case against secondary legislation, the challenges there, the process, but also the fact that, you know, we have a digital rule book, but a lot of the standards are not even there by the time companies need to comply. So I think guidance probably is the best approach at a first instance.
Thanks, Eugene. And yeah, I was looking at the volume of secondary legislation yesterday, and it's kind of 4 to 5 times the amount of primary legislation. So I think, you know, we need to think about ways to increase its quality and the scrutiny of it. But it does seem to be a way to balance prescriptive and principles-based laws, which brings me to Dries, because you're obviously at the forefront, the coalface of enforcement when it comes to digital fairness and consumer protection. So really love to hear what you think about the report and whether it gets the balance right between this prescriptive versus principles-based approach.
Yeah, thank you very much, Zach, and good morning, everybody. Good afternoon, depending on how you feel. Thank you to the authors for the production of this very extensive report. And I think there's 2 things that I really, from the outset now, want to highlight. The first one would be something that I particularly like, which is that for the first time, to my knowledge, in our European history, we're having a policy debate on whether we like personalization or not. And I think the report does really well to set out that, you know, there are definitely advantages that consumers can reap. I think providing choice to consumers whether they want to be personalized or not is also a very good proposal. However, I would not do that in an opt-out, but via opt-in would be very different. And I think also we need to make sure, and absolutely sure, which is probably already covered by current legislation, but I think wouldn't harm to have more explicit, if there is indeed that personalization should never abuse vulnerabilities of consumers. And contrary to the report stating that that should not take place in advertising, I would actually advocate that that would go for any commercial practice across the board, whether it's pricing or UX design or whatever. The second one, and I'm trying to be very brief, but this could be made into a very elaborate separate discussion, is the thing I like less, but not because the recommendations in the report on addictive design are not valid, but because I think the topic is actually taken too narrow. So I think we should definitely start to regulate non-economic harms. And I think increasingly we see business models moving forward to not just capitalizing on money, but also on people's time and attention. Our legislation does currently not cover that sufficiently. And I think there's a very strong case to make that, our time is scarce and limited, like our money. We can only spend it once. We have agreement for 20 years that manipulating people into spending money is an unfair commercial practice, but then, manipulating people into spending their time apparently isn't. I think that doesn't make any sense. So, from the ACM, we really feel that we start to look at, what the effects are, the undesirable effects of capitalizing on people's time, and this is where I'm referring to the too narrow. Addiction is one of the more extreme effects of capitalizing on people's time, but there are many others that are also very undesirable and could have health implications, which is absolutely something that we should look to protect consumers from. Thank you.
Thank you, and that's a good time or point on which to move to Tim from Tencent. I'm sorry about getting your affiliation wrong earlier. There's been a few points made already on issues that the report should have covered, or that the DFA should cover, including looking at gaming specifically, addictive patterns. It'd be really great to hear your thoughts on whether taking a really targeted approach to those issues is the right thing, or whether we should keep it to kind of a principles-based and business model neutral type of approach.
Yeah, thank you, Zach, and good morning, everyone. My name is Tim Stok. I work at Tencent, and just wanted to also say a word of thank you to CERRE for organizing this. It's not very common that you have regulators, academics, industry, civil society, lawmakers in the room, all discussing very important topics. So well done. Also on the report, appreciate also Christoph's summary. I think it lands on a lot of important things that we're talking about today. I think if you ask us at Tencent, and for those who don't know Tencent, it is a large international technology and entertainment company, all about making connections, whether that's through video games or a social messaging app WeChat, or our business users through cloud-based products. But what we thought in the report was very good was the risk-based approach that basically throughout the whole report is really surfaces. And I think if you, for us, video games, as a large video game company in terms of revenue, video games are not social media, right? And I think there's differences there. And even within the industry, if you look at video games, there's different business models, whether it's free-to-play, subscription, or one-off payments purchasing a game. But these all make sure that all of us, and I dare say all of us in this room as well, who play video games at times, right, are able to do so, right? So I think that's important to make that distinction. On the question of what could have been better in the report, I think that does make a reference to the prohibition of loot boxes. So for those who, loot boxes are randomized in-game purchases. They are non-mandatory, so it is an option if you want to enrich your game experience. And this is often been a point of contention, but I think if you look at it, it offers, again, to my earlier point, it offers video game players an ability to enjoy the game they are playing. And if you look at in-game purchases, only 95% of those game players actually never make a purchase in-game. So the video game caters to the wishes of a lot of our consumers. And if you go down the road of prohibiting loot boxes or the free-to-play model, or it chips away the free-to-play model, which is not good for a lot of European studios and game developers that rely on this as a business model. And just coming back on Dries' point as well about the time and the spend, I think that's also where the video game sector has taken massive responsibility in making sure throughout the years that there is, whether it's PEGI age ratings, but also parental controls that are able to install at gameplay, making sure that minors have limits whether it's spending money, whether it's spending hours or minutes on playing video games. And I think we also, as an industry, need to make sure that that is lands effectively at those guardians and parents. It is ultimately a shared responsibility, and that's what I would like to see.
Thank you. Now, Martin, you have the difficult job at the Commission of not only reading our report, which at 60 pages is, does have a lot of meaty material, but also, as we've heard already today, trying to synthesize a lot of different views from industry, from enforcers, from consumers about how to get the balance right. So it'd be really great to hear your reflections on kind of what you've heard so far.
Yeah. Thank you. Good morning. Yeah, indeed, the Digital Fairness Act is a big undertaking for our DG Justice and Consumers and for our unit in particular. In fact, maybe I can use this occasion to also explain that Digital Fairness Act is not, in fact, the only big project that we have for this year. We are also planning to propose a review of the Consumer Protection Cooperation regulation. In particular, we are moving towards providing the Commission itself with direct enforcement powers in most important cross-border infringements. And in this context, well, maybe you will be interested to know one of the things that we will likely need to do would be to transform some of our EU consumer protection rules, which are currently laid out in directives, into regulations, because this is a precondition, a legal precondition for the Commission to exercise direct enforcement. The Commission can only work on the basis of rules in regulations, not on the basis of directives as transposed into different national laws. So in fact, we are looking here at the Digital Fairness Act, which will be an act filling identified gaps in the consumer protection rules, and there are quite many, as have been mentioned by the speakers. We are looking at a revised consumer protection cooperation regulation, and very likely at a new unfair commercial practices regulation. So it's a big package and big undertaking. We are receiving and we are getting a lot of interest from the stakeholders. Our public consultation last year was quite a success. More than 7,000 respondents reacted to the survey or to the call for evidence, and very many hundreds of position papers from stakeholders. We continued consultations for several months, so surely in this room we have many representatives of organizations that had cooperated, that had given their feedback to our contractor. Many thanks to you for that. Now we are reached the stage of processing this rich data that we have collected. The timetable is in fact rather tight. We need to go to Regulatory Scrutiny Board already on the hearing is on 1st of July. So the timetable is quite tight, even though the adoption is planned by the end of the year. The report that Professor Bush and other co-authors have presented is very valuable. I read it with interest. It touches upon several of major areas that we want to tackle in the Digital Fairness Act. There are many measures assessed, and I would say practically all of them are also on our agenda, and we are looking and evaluating them in the context of our impact assessment. So I wouldn't like to single out one or two specific ones. I would rather maybe turn to the more general recommendations that Professor Bush announced. So meaning that the legislation has to be risk-based and design-based, and that we also should consider the regulation of a wider ecosystem of actors that are involved in these business-to-consumer transactions. So indeed, these are considerations that we are following. The risk-based approach has in fact led to us acknowledging that many of the provisions in the DFA should have a particular focus on the minors as consumers, because it is the young consumers who are more exposed to risks caused, for example, by different addictive design features. So the rules that we are considering may well be stronger as regards the protection of minors, so they could only address the protection of minors. As regards design-based, indeed we want to move away from just regulating by information requirements. We want to provide for mechanisms for consumers to exercise their rights more easily. So the cancellation button was mentioned in particular. Regarding ecosystem, it is indeed tempting to go beyond merely regulating the traders who are in direct contact, who are directly interacting with the consumers, and to go beyond. In some areas, we have some plans to do it. Of course, there are certain limitations. First, traditionally, EU consumer law has always been about business to consumer. And also, when we speak with some authorities, the questions have been raised about how enforcement could take place nationally in the context of business operators who do not have this direct interaction with the consumers, but who are providing services to other businesses who then use those services for targeting consumers. Also, if we speak about the platforms, intermediaries, one of the guiding principles for our work is that we do not duplicate what has been decided in the Digital Services Act, so we are not reopening directly or indirectly the rules that have been decided, especially for intermediaries. Of course, intermediaries are also traders. They are acting themselves. They are advertising, selling towards consumers, so they are fully subject to our requirements. So thank you. That's all I want to say briefly.
Thank you so much. Amelia, hopefully you can see and hear us okay. We're very, very sorry that you are not able to be with us in person, not least because you would have added some important diversity to all of us on stage. But really grateful that we can give you the right of reply, because you've obviously heard some compliments and maybe some constructive ideas for the report. So it'd be really great to get your reactions. Over to you.
Thanks very much, Zach. Yes. So first of all, we absolutely couldn't cover everything, or the report would have been huge. We do, though, and going to Urza's comment, we do talk about video games, but only the addictive design aspect of video games. But that is discussed in there. I think that most of the comments are well taken. I would just add a couple of things about the addictive design section, which I was the author of, and a couple of points that came out there. One was that although minors raise the biggest issues around addictive design, we were keen that we didn't only focus our attention on minors in the addictive design section. And we do think it's really important that addictive design is addressed for adults too, and particularly for younger adults, because just because you hit 18 doesn't mean that kind of magically you are resistant to all of the addictive design features that people are worried about. Another point that we were very keen to do, which goes to the risk-based but maybe hasn't been pulled out enough, and this is a general point, is about making sure that the regulation is future-proof. And therefore, one of the concerns in the addictive design features is we've all got very concerned about things like pull to refresh, infinite scroll, various gamification measures. But actually, if we specifically try and do things about those specific design features, there'll be new ones coming along. So it's really important that we design the regulation in a way that isn't specific to the current specific addictive design features we're seeing today, but that facilitates addressing any new ones that come along. And the third point was actually that even for minors, but particularly for adults in this area, having enhanced controls is the real key. So not banning things. I mean, there may be some potential to ban certain things in certain circumstances on a risk-based basis. However, for the most part, actually, we thought that there wasn't enough controls to actually allow people to switch off things that they were finding were leading them into rabbit holes or to spend too much time online. Or to generally control the overall amount of time or spending that they were doing online. So it was very much in that control space, and we thought that was quite different actually to standard consumer law, which is very much about providing prohibitions on suppliers. This would be to enable us as consumers and as citizens to control what we do ourselves more effectively. And I thought that was quite a new thing that hasn't maybe been pulled out enough. Thank you.
Thank you, Amelia. We've got just a few minutes left, but I'd really like to hear whether there's any questions from the floor. If you just raise your hand, someone will come over to you with a microphone. Okay, we've got a few in the back.
Hi, Caroline de Kock from the Lisbon Council. So in terms of the scope of consumers and the issue of subscriptions, I just wanted to raise that one of the stakeholders that kind of is lost in the middle of all the legislation of EU are cultural heritage institutions, and that covers libraries and also educational institutions. And when I say they're caught in the middle, is they're not really covered by consumer law, but they're not really covered by competition law when they have issues. And they are the people that face issues in terms of subscriptions when it comes to the collections that are in libraries. They are dependent on getting subscriptions from publishers that are quite powerful people. And with them, the problem is not getting out of the subscriptions. With them, the problem is keeping the subscriptions and keeping them at a fair price and keeping them in terms of what they want to subscribe to in terms of content. Because I don't know if you're aware of it, but your library no longer owns content. That was in the days of analog books, they were on the shelves and they had control over them. Now they rely on subscriptions. They are a middleman between a publisher and people coming to the libraries. And that creates quite a few bottlenecks and quite a few abuses. And I know some libraries have tried to get it on the Digital Fairness Act agenda by saying, hi guys, we're consumers too, to a certain extent, and we're not being treated fairly. And I would encourage you in the report and the follow-ups to maybe look at those things too. Thank you.
Thank you. I think there was one other question at the back as well. Please, yeah.
Okay, I don't want to take the floor as if I was a speaker, but yeah, from a digital rights standpoint, which are also fundamental rights, something that we have realized is that, responsibility doesn't work. Asking people to act responsibly on the internet because of how the design is structured and the architecture of choice is actually, aimed at exploiting the time, not just the money, but also the vulnerabilities. So when we realize that this is happening, then we have two options, right? Which is, either more controlled choices or banning. But when it comes to the control for the users and for the consumers, what we realize is that it's also about design, and dark patterns or disruptive design is also a huge part of that, right? There's people who, no matter how easy the control is or how easy companies and traders are saying that the control is, it's impossible for them to actually exert that control, and this is why there might be a need for banning or limiting the use of some of these features. So yeah, I would really like you to weigh on that, because I think it's good to speak about control, and I'm all for privacy signals, but control also has to be designed and has to be easy and simplified for the consumer and for the companies, if I may.
Thank you. Just a reminder, if you're on Zoom, you can feel free to ask a question in the Q&A, and it will make its way to me, so please feel free to do that. Were there any other questions to take here? Just one in the back there. Sorry.
Thank you so much, Vanessa De Palma from MNEMPA. I just wanted to ask all speakers, how do you see the interplay between the DFA and other pieces of legislation, either already tabled or upcoming? I'm referring, for example, to the digital omnibus, that if approved as proposed, would centralize consent requests at browser level, but also the upcoming ongoing digital fitness check that might even, in a way, rewrite the DSA. Thank you so much.
Thank you. I think that's it, but please do raise your hand if there's anything, any other question anyone wants to raise. Peter, there's a microphone coming to you. So.
Thank you. Just a small observation in light of the fact that it's come up on a number of occasions. We've got this dilemma between European Union pushing for more and more regulations rather than directives because of the direct effect and so forth. On the other hand, we've got the democratic deficit of too much secondary legislation without going through the appropriate democratic checks and balances. One of the biggest problems I find as a lawyer over the last, say, 5 or 6 years has been the tendency of overuse of the regulation, and I understand why, but the problem with the regulation is it's supposed to be of direct effect because it's absolutely crystal clear as of the day of its implementation. But if you are talking about general principles, it's never clear because it's applied in the future. Therefore, a lot of this general principle stuff in the form of a regulation is a real problem because it is implemented at the national level, and that's a directive, and that's for national courts. And I think we're getting ourselves into a bind here, and we need to be wary of it. Because some of this stuff might just be knocked out in the future because judges in the European courts just think it's unclear how it's going to apply in practice.
Thank you. Yeah, as you say, I think this is a big problem with the whole actification of the rulebook. I'm just wondering if, Christoph, you would like to kind of comment on anything that has been kind of raised in the panel so far, maybe to supplement what Amelia has said.
Well, maybe if I may add two very brief points. One is enforcement. We haven't talked so much about enforcement. And sometimes you hear the EU should rather focus on the enforcement of the existing rules. But I think also in the context of the DFA, it is very important that we think about enforcement from day one. We might call this enforceability by design. So the rules should be drafted in a way that they can be enforced easily and effectively, and that's important, vis-à-vis all actors on the market, regardless where they are based or so. So I think that's a very important task when drafting the DFA, that enforcement is on the mind of the drafters. First point. Second point, I think there is a very strong EU single market angle or dimension to the DFA. And we've heard in the keynote address at the beginning that trust is very important for the market to function. And I think the Digital Fairness Act can be an instrument to facilitate trust of consumers if it's well drafted. And I think it's not so much a question whether there will be rules or whether there will not be rules. I think the question is whether there will be rules at member state level or at EU level. We're seeing member states pushing in this direction. We see rules on influencers in France. We see rules on digital contracts in Germany, France, most recently in Spain. So things are happening. And I would rather prefer to have horizontal rules at an EU level. That will facilitate the EU single market. So I think that is also a very important dimension of the DFA.
Thank you. And I think to give all credit to the Commission, often you see these proposals that do not allow opt-outs or gold plating, but as the legislative process continues, you know, they find their way into the text. But I think that's very much a responsibility for the Council and to some extent MEPs to address. We have just a minute or two left for each panelist to maybe make some final remarks. There's obviously been a lot of questions. I don't expect you to answer all of them, but maybe just those that seem most pertinent. And if you can keep it quite short, that'd be really helpful.
Thanks a lot for the great questions. Many questions I would like to comment on, but I focus on one point. enforcement. I'm glad that this was mentioned. The Digital Fairness Fitness Check report found that enforcement of consumer law is insufficient. And thus, many argue that all the problems that have been identified in the Fitness Check report could be solved by simply improving enforcement. But that won't work. Because although we fully agree that we need to improve enforcement, and we are grateful to hear that the Commission is now preparing a version of the CPC regulation, solely focusing on improving enforcement will not be enough. Why? Because enforcement can only be as good as the quality of the law that should be enforced. And that's the key finding of the Fitness Check report. The law is unclear. The UCPD, the Unfair Commercial Practice Directive, as one of the key instruments of consumer law, is 20 years old. It is outdated. It urgently needs to be updated in view of the realities of the digital market nowadays to make things clearer. Because if we don't clarify what's in the law, this will have a chilling effect on enforcement. People will not try to enforce their right because they don't know whether they will succeed or not. So we need to do both. We need the DFA to update consumer law, and we need to revise the CPC regulation to make enforcement effective. Thank you so much.
Over to you, Leonard.
Yeah, 2 points. Maybe one point on, and we discussed about, I think, in the context of the addictive design discussion and sort of feature-specific logic. I think what I want to stress is that, and I think most of us here in the room are aware of that, not all time that is spent online is the same. So there's difference whether I spend time online on communicating with my friends versus just spending time on passively consuming feeds of content. I think that is important. So I think what I want to say is I think service design context matters. I think this also became clear in the report, and also the context in which specific features are deployed matters. And I think there is a lot of academic literature that really points to the the different effects that use patterns of certain services have on users, and then I just want us to keep this in mind when further discussing issues like addictive design. I think that is very important. And the second aspect, just briefly, I think it's encouraging to especially also to listen to Martin, and I think there's a strong commitment in avoiding overlap and just focusing on coherence. And I really hope that that we all stick to that, despite the huge political pressure these days, and it's coming from all directions. And I think there is a perceived ineffectiveness of the existing framework. I think we need to be honest here. This is also what's driving concerns in the area of minors protection, minimum age restrictions, etc. So I think just sort of better market the existing framework, I think, is one thing, and then just continue to focusing on enforcement.
Thanks, Leonard. Eugene, any last advice for the Commission as it kind of takes on its task of drafting this up?
I'll try and be brief. No, I think enforceability is key, and I think Peter and Christoph and Atassa also made it, and Urs made a number of important points there. I think in the context of better regulation, as we approach the CPC regulation, I do think it is important to consider the centralized authority, a centralized enforcement strategy, and coordination between different authorities. And I think it would be helpful, I mean, you've mentioned that the Regulatory Scrutiny Board process will be in July. I think the CPC regulation was reviewed and the report was 2022, maybe, if I'm wrong. So I think it would be helpful for stakeholders to be able to weigh into what that enforcement framework should look like, as well as the implications for a regulation. And I think Peter has made that point there. So I think it would be really interesting to discuss those points in more detail before we look at an enforceability mechanism for the DFA. And maybe just finally, to Urs's point on the having rules that are specific enough to be enforced, but at the same time flexible. And when it comes to what we're terming here addictive design patterns, I think it is important to have a clear definition, which also doesn't make a judgment. So the report lands on persuasive design features in predominantly engagement, borrowing the language from the DSA. And I think this is a good example of how we can actually define the underlying problem, not just focus on certain features. And I think it is very clear that certain features that have positives, have negatives potentially, and then we need to actually look at what the underlying issue is. And I think CERRE makes a really good contribution to that discussion.
Thanks, Eugene. Dries, any final perspective from a kind of a regulatory angle?
Yeah, thank you very much, Zach. Just quickly, 2 points I wanted to reflect upon. One was the gentleman here in the middle mentioned that principle-based legislation doesn't work. I am the biggest fan of the system that we currently have in the European Union, which is a mixed system of principle and rule-based legislation. I think it's beautiful because the rule-based part makes sure that you get the clarity that you want. The principle-based part makes sure that it's future-proof. So we're doing both at the same time. And yes, we need to update the system. We can introduce new rule-based prohibitions that we know now should be there, and that's definitely, I agree with Urs, very badly needed. But we should not throw away the principle-based approach, and that's also where I'm going to push back against the resistance, although I do understand the reason why, but the use of secondary legislation. Secondary legislation can be adopted and changed much more quickly than primary legislation, also in order to stay future-proof, which benefits both businesses as well as consumers. So I definitely see a role there for secondary legislation. And my final point is going to be, when drafting the DSA, let's please bear in mind that none of us here in the room are rational consumers. We have a vast body of empirical evidence to suggest that we make decisions not based on all the information that we have and not always in our best interests. Certainly not minors. I mentioned the opt-out instead of, or the opt-in instead of the opt-out rule. I think someone in the back of the room mentioned something about, to what degree can we rely on people making the right choices when it comes to design. And they want to turn off or on. Parental controls in gaming is another issue. I think there's all across the board some very, very serious discussions that we need to have on what we can expect from people in reality. Thank you.
Thank you, and over to you, Tim.
Thanks, Zach. Just want to quickly pick up on 3 things. So Amelia mentioned the enhanced controls. The point I made earlier, and parental controls in video games are actually quite good, right? And they're not the silver bullet, I admit, but they do allow a player or younger minors, when they play video games for their parents, to send or set time limits, set spending limits, to set who they can and cannot chat with. And I think it also really helps for parents or guardians to actually play with their kids, right? I would recommend all of you in the room also to spend a couple of minutes a day just playing with their kids. It's actually quite fun. And the second point about, or the question in the back on how the relationship with other pieces of legislation. We would argue, I think, an harmonized EU Act obviously benefits all game developers, game publishers, because you have one set of rules as opposed to 28 fragmented. And I think that also in relationship to the last point I want to make, one thing that obviously the Commission has been saying a lot, and we're glad to hear, is the competitiveness angle in all of this, right? And European competitiveness is being pushed as an agenda, which I think is personally is a very good thing. I think coming back to the video game sector as well, it is a proud industry that of game developers, of publishers that create wonderful products that are enjoyed by about half of the population in Europe. So it is something that we should also be proud of. And I think the Dutch Games Association also wrote a good letter, and hopefully it arrived at the Berlaymont to talk about prohibiting some things around virtual in-game currencies, which actually would be very much to the detriment of those developers, of having them be able to develop those games. So the competitiveness angle, I think, is also something that we should definitely not overlook.
Thank you. Martin, if you just have a minute or two to just wrap up the conversation. You've obviously got a lot to respond to, but maybe just letting us know kind of where the Commission is heading from here would be helpful.
Yeah, thank you. Well, I certainly fully agree with all the speakers who said that the enforcement of consumer protection rules is a key consideration, and it is indeed one of the main drivers for our work on the DFA. We want to introduce in EU consumer protection framework more concrete rules which are addressing the current most important problems. At the same time, we will, of course, keep our core provisions, which are principle-based, because indeed this is a buffer that enables us also to tackle problems which we are not even aware about at this given moment. And it's also important considering how long it takes for the decision-making process at the EU level to be completed. So we need to introduce rules which on the one hand, pass a clear message to the traders about what behaviors are prohibited. So we may go for specific prohibitions of concrete types of dark patterns, so interface design features, from which the traders will be required to refrain. And we expect that such clear message will also result in high level of voluntary compliance, which means that our consumer protection enforcement authorities will be able to dedicate their limited resources to tackling those who are persistent and who do not want to comply. But in a situation where 90 or over 90% of traders, as some of our surveys have concluded, have practices which are questionable, which may constitute dark patterns, we cannot envisage that simply continuing to enforce on the basis of current principle-based rules, we can solve the problem. We need to give stronger and clearer guidance to the market. Thank you.
Thank you so much, Martin, and thank you to all of our panelists. Please give them a warm round of thanks.